Oh yes, oh yes, oh yes, God save the state and this honorable court. Please be seated and remain quiet. Please turn off all electronic devices at this time.
All right. Good morning, ladies and gentlemen, again. The bailiffs report to me that we have 14 jurors present. Are there matters that we need to take up outside the presence of the jury?
Yes, Your Honor. Some stipulations to inform the court about. I'll inform the court's the state's understanding that counsel will enter the following stipulations. Marked as State's Exhibit 1, 2, and 3 will be some RBC PNC bank records of the Brad Miller congressional campaign. It's my understanding that counsel stipulates to the authenticity and admissibility of those records provided, now referred to as State's Exhibit 1, 2, and 3.
That's correct, Your Honor.
Thank you, Mr. Arp.
Judge, there's State's Exhibit 88. This will be, it's bait stamp pages for counsel's purposes 7065 through 7118. This is the Sprint phone records of phone number 919-332-4520, which will be identified in the records as the defendant's Sprint phone records for the month of April 2013. There's stipulation to the authenticity and admissibility of those phone records. State's Exhibit 88.
Mr. Arbor.
Yes, Your Honor. And while we're doing it, it's just a matter of, so you're aware?
Yes, sir.
Mr. Fawcett, in providing us with the discovery, had initially provided us with whatever initial packet came into him on the case, and then it started to become a little more voluminous. So as a matter of organization, he bait stamped all the material. What he had previously provided was included in the bait stamp material. We have, I think he would agree, material that numbers from pages 1 through 8006. Is that correct? I think that's right. So what we just indicated, we anticipate that we're going to have witnesses on the stand where we might want to reference, and it may end up on the record, certain pages that will help us all get to the pages that we're looking for without maybe perhaps mentioning a specific date of a certain report. It'll just make it a lot easier. So if we do that and it's in those page numbers with the court's permission, we'll do that. And I think that's why Mr. Fawcett has included the bait stamp numbers on the exhibits he asked us to stipulate to. So we just want to make you aware of it so that when we're talking about these numbers, you know what we're talking about.
And that's fine as long as the exhibit that's marked and is offered for admission also has those same numbers so that the record is clear as to what numbers are being referred to, and that the marked exhibit also has those same numbers. As long as we can do that.
I anticipate what we'll do is we'll identify the exhibit for what it is, and then we'll also, for whatever date's on it and whoever authored it, and then we'll probably reference it by its bait stamp numbers just so that we're on the same page and it's consistent.
Correct. And some of the exhibits do not have bait stamp. They were voluminous printouts from CDs provided and all, but I think both counsel and myself are all on the same page.
Yeah, if there's no bait stamp, then we're referring to one of those other documents.
That's fine.
Judge, the next stipulation is State's Exhibit 103, which is the Wells Fargo checking account records of Jonathan Broyhill. That is stipulated to as to the authenticity and admissibility. I'll inform the court that those specifically, while the exhibit is not bait stamped, they encompass bait stamp numbers 5879 through 5887. With this stipulation as to the month of April 2013, specifically March 27, 2013 through April 24, 2013. That is stipulated to be authenticated and admissible. The state parties enter into a reciprocal stipulation that if either side desires further Wells Fargo, Jonathan Broyhill banking records, they are authenticated and admissible as well. Is that correct, Mr. Earl?
That's right. In other words, we won't be required to bring in witnesses to authenticate them. We've agreed that they would be admissible for not as to relevancy, but as to authentic documents.
All right.
I'm sorry.
And that's your understanding, Mr. Foster, as well. Relevancy still remains.
Right. We have a couple of years worth maybe of records, and
I don't think
various
that
parties maybe decide that it becomes relevant or needed.
And I think in the discussion I don't think there's anything in any of these records that Mr. Fawcett anticipates, and these records that Mr. Fawcett anticipates having any objection to, but we'll address those things if they should arise.
Your Honor, the next stipulation is referred to as Orbit's records. These are separate exhibits. One is State's Exhibit 104, which is a 3-page document, bait stamp 713 through 718. Back and front, bait stamp, 3-page document. I refer to this as the certification of the business records. State Exhibit 104 from Orbit's is stipulated to as being authenticated and admissible. Then related Orbit's records, State's Exhibit 105, which is bait stamp pages 6823 through 6832, 6823 through 6832. These are stipulated to as authenticated and admissible Orbit's business records, and these are more of the emails and cancellation debit card information. State Exhibit 104 and 105 is my understanding of the joint stipulations.
Okay,
Correct, and I believe the discussion on this one was that because we're allowing this in, and all the documents we have with respect to this we've received from Mr. Fawcett, on that issue, on the Orbit's things, anything related to, because there's other emails, I don't anticipate getting in any of the other ones, but I think we indicated that you had no problem with us bringing that up, also for relevancy issues on that one.
The Orbit's.
On the Orbit
Yes,
stuff.
absolutely.
It's fine.
Judge, finally, parties have entered into a stipulation to the authenticity and admissibility of State's Exhibit 14. This is referred to as a CD that will have 3 recordings between a bill collector and to be identified as 2 of them are with Jamie Hahn and 1 is with the defendant, Mr. Broyhill. To the authenticity and admissibility of State's Exhibit 14. The bill collector will testify this morning. State's Exhibit 14 is the CD. Is that right, Mr. Hall?
That's correct. There are, and with respect to that, Judge, I believe the part of the reciprocity is there are other recorded calls, which we may or may not get into, and if there is, there'd be no objection to those coming in. These are just the 3 that the state have chosen to produce.
The state has provided all the phone calls they have pertinent to the case from the collection agency. The state would agree that if Your Honor finds any of that matter relevant, that they're authenticated for argument to the court about admissibility on relevancy grounds. Is that right, Mr. Arbor?
Correct.
Including, if you so desire, transcripts or any business records supporting these that have been provided and discovered from PRC.
Correct.
Judge, the last stipulation related to the recordings is State's Exhibit 15. This will be referred to as the business records of Professional Recovery Consultants, PRC. These records are stipulated to us to be authenticated and admissible. They end on April 25th, 2013 is the last entry of these stipulated to business records. There are other records that go past that date that if a party desires and the court finds to be relevant, they are stipulated to us authenticated by the parties.
That's correct. That's
All right.
understand.
Very well.
Those are the stipulations the parties have reached at this point in time. The state has one other observation or question. I do see that the jurors have been provided notes, notepads. The state has no objection to the jurors taking notes. The state was curious if those could be provided after the opening remarks. I think that my experience is after the attorneys talk, then the notes for the actual trial and provide the notepads.
I'm happy to take that into account. Let's talk about the notes. It's my practice in trials, particularly ones that are lasting more than a day or so, to allow jurors to take notes in my discretion. I give them an instruction regarding their note-taking. And Mr. Fawcett, you've indicated no objection to that. Mr. Arbor, do you wish to be heard on the issue of note-taking?
No.
All right. And we will go ahead and hand out the notebooks immediately prior to the evidence in this case, if we can make arrangements to collect those notepads before the jurors come in.
Judge, just for the record, there was an issue, we don't need to, it's on the record regarding opening statements and evidence. You had just indicated that there was going to be any change from your ruling yesterday that you would advise us this morning. Is there any change to that ruling?
No, and that was a topic that I have on my list. So I have determined in my discretion that the ruling that I announced I was inclined to give will be the ruling of the court. And that ruling is there is a calendar for April 2013 that Mr. Fawcett intends to use as a demonstrative aid during his opening statement. And in my discretion, I would allow that. I do find that it will aid the jurors in understanding the timeline in this case, and so it's appropriate for a demonstrative aid, and so in my discretion I will allow that. I note your objection that you raised yesterday with respect to that exhibit.
Thank you.
Or aid, excuse me. With respect to the other, I believe there were 3 photographs that Mr. Fawcett requested to use, and in my discretion I declined to allow those to be used during the opening statement.
Thank you, Your Honor.
And in fact, I'm going to, in my orientation of the jurors, when I explain to them the purpose of the opening statement, I'm going to, normally we just simply explain that the opening statement is not evidence, but I'll also elaborate on that and indicate that any demonstrative aids used during opening statements are not evidence.
That's fine. This may be premature, Judge. There's a witness that Mr. Fawcett has indicated to me he anticipates calling if they get to that stage of proceedings today. I don't think it's his first witness. At that point, it's a gentleman by the name of Charles Williford. Just to alert you, in case we forget, we'll want to approach or put something on the record with you because we're going to probably request some court instruction with respect to that particular witness.
All right, that'll be fine. If you'll just alert me to...
We'll try to remember. I just try to let you know so I don't forget later on.
That's fine. And Mr. Fawcett, when you get to the point where you intend to call that witness, if you'll let me know so that we can make arrangements to allow everybody to be heard on that.
All right, thank you, Judge. Inquiry, Judge, the state has just brought to my attention. I probably should ask that. I know you've permitted over my objection cameras in the courtroom. Is there with respect to microphones, I want to make sure that there's nothing being recorded at our table while, and that, I see that one's on.
And mine's taped over the little light. I don't like to record it when I'm talking to privately myself. So that was I don't know what is or is not, and I can see that it's usually not taped over. Now it is.
The Rule 15 of the General Rules of Practice make it clear that the media is not permitted to record or capture the conversations of counsel at their counsel table that are not being addressed to the open court. I would urge you to get in the habit of turning your microphone off. I'm not familiar. My understanding is that the wiring of these microphones eventually ends up as a media feed, and so that microphone is the same microphone that the media uses to capture your remarks in open court.
Okay.
So I think the best practice would be for you to simply make sure that it is turned off whenever you intend to have a private conversation among yourselves.
And I know Your Honor has already heard my motion with respect to the media. I guess I'll specifically make just note my objection to the fact that there are any recording devices, audio, video, whatever, anywhere near the defense table throughout the trial.
All right, anything else we need to take up?
Not from the state, no. Thank you.
All right.
Nothing further from the defense, Your Honor.
All right, very good. Then let's we've got the notepads taken up, is that correct? All right, let's go ahead and bring jurors up. Good morning, ladies and gentlemen. Welcome back. Thank you all for arriving promptly so we can get underway. I know some of you have been away from us for the past several days. Some of you were just here the last several days, but we thank you all for listening carefully to the instructions you've been given and arriving back so that we could get underway. The first thing we're going to do this morning is the clerk will impanel you as jurors in this case. And then I'll give you a brief orientation as to how we'll proceed in this matter, and then we'll move directly into the opening statements in this case. So, Madam Clerk.
Ladies and gentlemen of the jury, you have all been duly sworn and are now impaneled to hear the evidence wherein the state of North Carolina versus Jonathan Wayne Broyhill. Sit together, hear the evidence, and render your verdict accordingly.
So, ladies and gentlemen, you've now been selected and impaneled to serve as jurors in the case of the state of North Carolina versus Jonathan Wayne Broyhill. And at this time, I want to explain to you a little bit more about the manner in which we will proceed as we attempt together to find the truth in this matter. First of all, the lawyers will have an opportunity to make an opening statement. The purpose of an opening statement is narrow and limited. It's an outline of what the attorney believes the competent and admissible evidence will be. An opening statement, what an attorney says during an opening statement, and any demonstrative aids that are used during an opening statement are not evidence and must not be considered by you as evidence. Following the opening statements, evidence will be offered. Witnesses will be placed under oath and will be questioned by the attorneys. It may be that documents and other tangible exhibits are offered and received into evidence, and it may be that those exhibits are given to you to examine. If you are given an exhibit to examine, you should do so carefully, individually, and without comment. It is the right of a lawyer to object when testimony or other evidence is offered, when the lawyer believes that evidence is not admissible. When the court sustains an objection to any question, the jurors must disregard the question and any answer if one has been given, and you should not speculate or guess as to what the witness might have said had the witness been allowed to answer the question. When the court overrules an objection to any evidence, you must not give that evidence any greater weight than as if the objection had not been made. If the court grants a motion to strike all or some of the answer of a witness to a question, you must disregard and not consider that portion of the evidence that I instruct you has been stricken. Now, during the course of this trial, there may be questions that will arise that will require us to consider outside the presence of the jury. When this happens, I'll ask you to leave the courtroom. I'll call a recess for your benefit if it's going to take us a bit of time to consider, or if it's a relatively short matter, I'll send you back into the deliberation room while we consider those matters. But in any event, you should not concern yourself about what's happening in the courtroom during your absence. Again, these are matters that the law requires us to consider outside the presence of the jury. And you should rest assured that all of the competent and admissible evidence in this case will be presented while you are in the courtroom. When the evidence is completed, the lawyers will have an opportunity to make a final statement or a final argument. These final arguments of the attorneys are not evidence, but are given to assist you in your evaluation of the evidence. And then finally, before you retire to consider your verdict, I'll give you further instructions on the law that you are to apply in this particular case. At that time, I will declare the law that arises from the evidence, and I will explain that law to you. You will then be taken to the jury room to deliberate upon your verdict. Now, I've already gone over with you the rules that you must follow as you sit as a juror in this case. I'm going to go over those rules one more time in a bit of detail. And as you all know, I'm in the habit of reminding you of those rules prior to every break and recess in an abbreviated fashion at least. But these rules are very important, and we ask that you follow them carefully and understand them completely. Again, the first rule is you must not talk about this case among yourselves. The only place you may talk about this case among yourselves is in the deliberation room, but only at the end of the trial after I've instructed you to begin your deliberation. The second rule is please do not talk about this case with anyone else or allow anyone to talk about it in your presence. This would include family members, friends, co-workers, anyone at all. If anyone attempts to communicate with you about this case, you should bring that to my attention immediately. Third, as you sit as a juror in this case, you should not form or express any opinion about the outcome of this case, namely the guilt or innocence of the defendant. Again, this rule simply requires that you keep an open mind throughout these proceedings. You will form and express your opinions once you begin your deliberations at the end of this trial. Fourth, please don't talk or communicate in any way whatsoever with any parties, witnesses, or lawyers. Again, there are a number of people who may be witnesses in this case or involved in this case that are not present in the courtroom, so you need to use extreme caution in talking or communicating with anyone around the courthouse that you don't recognize. It may be that that person is involved in the case, and your communication, even if inadvertent, would be a violation of this rule. You all now have red badges. Those red badges identify you as jurors. That helps all of us avoid communicating with you in any way. It helps us comply with this rule as well. And again, this rule applies both inside and outside the courtroom, and it applies even to casual conversations such as the time of day, the weather, or any other matter. Fifth, we ask that you not conduct any independent investigation into this matter. We ask that you not go home and look at any books or internet research or any other type of research into the people, places, facts, law, things, or anything else related to this case. We want the information that you base your opinion in this case to be information that you received from this courtroom and not from some independent source based on your own independent investigation. And then finally, we ask that you not read, view, or listen to any media accounts of this matter as you serve as a juror. Again, media accounts can contain erroneous information, or it can contain information that's not appropriate for jurors to consider, and so you're instructed not to read, view, or listen to that information. As I've explained to you, there is media coverage of this case, and so you're going to need to use extreme caution anytime you are around any media outlets, be that your home newspaper, your television, your radio, internet sources, whatever sources of media are out there that you may be exposed to. You need to use extreme caution that you not review or listen to that coverage. I'd also just note that there are cameras in the courtroom. There's video camera. There may also be still cameras from time to time in this courtroom. The operators of this equipment are very familiar with the rules and procedures of this court relating to media in the courtroom. One of those rules is that under no circumstances are jurors to be identified or filmed during the course of these proceedings. And so you should rest assured that you will not be the subject of any of the coverage that is here. That is a strict rule, and these operators understand the scope of that rule and comply with that rule. But in any event, you should not be distracted by the fact that media is in this courtroom. Your job is to focus on the evidence, the arguments, and the law in this case, and we ask that you do that and pay no attention to the fact that there is media coverage in this case. Now, each of you must follow these rules to the letter. These rules are an order of this court, and your failure to follow them could subject you to contempt of court. But more importantly, as you can see, these rules are designed to ensure the fairness of these proceedings for all involved. There are a couple housekeeping matters that I want to go over before we get to the opening statements. So first of all, in my discretion, you'll be allowed to take notes during this case. When you begin your deliberation, you may use your notes to help refresh your memory as to what was said in court. But I caution you, however, do not give your notes or the notes of any other jurors any undue significance in your deliberation. All of the evidence is important. Do not let your note-taking distract you, and listen intently to the testimony. Any notes taken by you are not evidence in this case. Your notes are merely to assist your memory and are not entitled to any greater weight than the individual recollection of the other jurors. Now, you'll be given notepads to take notes in. We'll provide those notepads to you right before we begin the evidence in this case, namely right after the opening statements. I will ask that you use those notepads if you wish to take notes. If you need additional notepads, the bailiff will be happy to comply with that. They'll provide you pens as well. Those notepads remain in the courtroom at all times, namely during breaks and recesses. I'll generally remember to remind you to leave your notepads in your chairs. In the evening, the clerk takes custody of those notepads, and they're kept in safekeeping until the next morning when they're put back in your chairs for your use. The only time those notepads will leave the courtroom is when you retire to begin your deliberations in this case. And so we ask that you do that. The other thing I'll point out, if you're given a document to examine and review during the course of this trial and you wish to take notes about that document, do so in your notepads rather than on the document itself. It will likely be that document will be taken back up from you, and so whatever notes or highlights or underlines you might have made won't be there for your use later on. So if you wish to take notes about something that you're reviewing, simply take them in your notepads so that you'll be able to retain those. The next thing, we've talked about the schedule that we follow in this courtroom. I think all of you are well aware of that now. We generally start at 9:30 in the morning. We go till 5 o'clock in the afternoon. We take a mid-morning recess of about 15 minutes. We break for lunch somewhere between 12:30 and 1 o'clock. And we then take, once we resume, we take an hour and a half generally for a lunch recess. Once we resume in the afternoon session, we'll take another 15-minute recess somewhere during the afternoon, and we attempt to recess no later than 5 o'clock. You can assist us in keeping to the schedule by arriving like you did today, promptly after every break and recess, so that we can get underway and have everybody in places when we are scheduled to begin court. So allow yourself plenty of time to negotiate the traffic, the elevators, the parking, anything else that may delay you, and we certainly will appreciate that. The next thing, your comfort is of great importance to us. If there's anything you need for your comfort, please let the bailiff know. You should feel free if you wish to bring cups of coffee or drinks into the jury box. I prefer you have a lid on it so that we don't mar our beautiful new courthouse here, but you're welcome to do that. The jury deliberation room is your room for the duration of this trial. You can leave snacks, lunches, books, sweaters, whatever you care to back there. That's a secure hallway, so you should feel free to use that room as need be. And it's very important that if you have any personal needs, if you need a break or something, just raise your hand. We'll do what we can to accommodate you. It's also very important that you be able to see and hear everything that's going on in this courtroom. If there comes a time that you can't see or hear something, a witness or an attorney or myself, let us know. Raise your hand, catch our attention quickly so that we can take steps to make sure that you can see and hear everything that's going on in this courtroom. Finally, I'd like to point out that from time to time, you'll see me working on matters up here at the bench, either on my computer or in reference materials that I have available for my use during this trial. I'm generally working on matters related to this case, and I do listen to every word that's being said in this courtroom. But I tell you this because I don't want you to be distracted by anything that I'm doing on the bench. Your job is to listen intently to the evidence in this case, and you should not assume from anything that I'm doing that any evidence is any more important or any less important. All of the evidence in this case is important, and you should listen carefully to all of the evidence in this case. All right, at this time we are going to turn now to the opening statements of counsel. We will hear the first opening statement from the state, and then Mr. Arbor and Ms. Elliott, if they wish to make an opening statement at this time, they will have that opportunity as well. Mr. Fawcett.
Thank you, Your Honor. Thank you, Mr. Arbor. Ms. Elliott. Your Honor. Good.
Yes, sir.
Your hearts will break. Your hearts will break. She was young, 29 years of age, full of energy and dedicated to others, politically minded, greatly invested in her community. She very much cared about public service, to give of yourself to others. She cared. That was Jamie. Jamie grew up in Orangeburg, South Carolina, and after graduating from UNC at Chapel Hill, she would go on to meet her future husband, Jamie Hahn, as they were working on the same political campaign together in 2007. Jamie and Nation shared the same political sensibility and desire to get involved, and they would go on and enjoy working on another political campaign to follow. Nation can tell you from their first kiss, they were engaged 4.5 months later, and they were married in April of 2009. By all accounts, they were outgoing, well thought of young couple. Nation certainly adored his wife. 4 years later, in 2013, Nation and Jamie were living in a North Raleigh neighborhood on Tillwood Place in a 2-story home. And from this residence, Jamie ran her own political consulting and fundraising firm named Sky Blue Strategies, named in part for her love of all things UNC. Now, this trial will not be about how talented or how thoughtful Jamie Hahn was. These proceedings will focus on why Jamie is no longer with us. And the reason why is the defendant, Jonathan Broyhill, selfishly murdered her. The defendant, someone Jamie considered a dear friend, someone Jamie hired to work for her at Sky Blue. The defendant on April 22nd, 2013, relentlessly attacked Jamie with an 8-inch bladed chef's knife while they were meeting at her house to discuss some unresolved financial issues involving a particular Sky Blue client. Now, what is important here is the defendant's conduct that violent day, the choices and decisions he made. But some context of the lead up to Jamie's murder should be of assistance to you as you prepare to hear testimony in this case. Jamie first met Jonathan Broyhill when she started dating Nation. Nation and the defendant grew up in Lenoir, North Carolina. They went to the same church. And Nation, who's 4 years younger than the defendant, when Nation was in high school, he and the defendant became friends. And they were the best of friends. After Nation went off to college, they didn't hang out as much. But once Nation graduated from UNC in 2008, the defendant and Nation reconnected, and they were the best of friends. And so through Nation, Jamie meets and becomes the best of friends as well with the defendant. And he would go on to be their best man at their wedding in April of 2009. In 2010, Jamie would hire the defendant as her only other employee at Sky Blue Strategies. And in 2011, Jamie would entrust the defendant with substantial financial responsibilities as to Sky Blue's signature client, U.S. Congressman Brad Miller. Sky Blue was now managing Congressman Miller's campaign account. The division of labor was the following. Jamie would handle the fundraising side of business for Congressman Miller's campaign, and the defendant was responsible for the accounting and reporting side of the business. And what that meant as to the defendant's responsibilities was he was the one entrusted with the checking account of the campaign. He was the one that would maintain the checking account, would write and issue checks. As to the reporting or compliance side of the defendant's responsibilities as to the Brad Miller campaign, what that entailed was the campaign, the committee, would have to report quarterly to the FEC, the Federal Election Commission, every quarter how much money the campaign brought in, how much money the campaign spent during that relevant time period, and the bank balance of the campaign's account. The evidence will show within months of assuming that position of trust, the defendant begins to embezzle thousands of dollars from Congressman Miller's account by writing himself checks. Now, solely as background here, the details are not particularly important. Congressman Miller announces in early 2012 that he was not going to seek re-election into the November 2012 election. And with that, Congressman Miller desired to start winding down his campaign affairs and accounts in anticipation of returning to the private sector in 2013. So with that, Sky Blue's responsibilities evolved. The fundraising stopped, and basically Sky Blue's responsibilities were greatly scaled back, and they were mandated with helping resolve and close down Congressman Miller's campaign affairs. One aspect of the wind down process was the campaign needed to pay back Mr. Miller for some personal loans he, like candidates often do, make to their own campaign. Bear in mind the candidate and the campaign are separate entities. And so the campaign needed to pay back these loans that Mr. Miller had made. As a financial issue in this matter, the defendant was responsible for handling that issue. The process of winding down Congressman Miller's account would remain unresolved into 2013. One of the issues that frustrated the wind-down process was the defendant, Jonathan Broyhill, stopped working for Sky Blue at the end of 2012. Jamie, now with their signature client going back in the private sector, didn't think there was going to be enough work to take on a second employee. And so at the end of 2012, the defendant stopped working for Jamie. Yet in 2013, with these unresolved issues, Jamie was still dependent on the defendant's cooperation. The defendant still possessed a variety of campaign property and financial materials, and she was dependent on his cooperation to transfer custody of these variety of items and to educate her about what had been done, what had not been done, the financial status of the campaign wind-down process. The evidence will show that the defendant proves hard to pin down in cooperating with Jamie in that endeavor. The evidence would also show the defendant would not be deterred, however, from continuing to steal campaign funds well into 2013. The evidence shows from June of 2011 into March of 2013, the defendant will unlawfully write 39 checks made payable to himself off the campaign's account, totaling $46,500 plus. The second issue that further frustrated Jamie's ability to bring resolution to these Brad Miller wind-down issues was the defendant's awful serious health issues. In mid-2012, the defendant announced he suffered from MS. He would often speak of these lesions on his brain and the ongoing treatment and different types of treatment he was receiving for that debilitating disease. He would speak of the effect it had on his memory and his ability to show up and to work. Next, the defendant would complain of painful gallstones and would announce that he needed gallbladder surgery, and it was supposed to be in March, end of March, and it got pushed back to the beginning of April. After the defendant's gallbladder surgery, he would tell Jamie and Nation that at a post-op appointment with the surgeons, they had identified a concerning spot, believed he suffered from pancreatic cancer, but would refer the defendant to an oncologist for confirmation. And with that, further oncology appointments would follow. So the evidence would show that as each medical issue materialized, Jamie would step back from pressing the defendant to meet with her, transfer these materials, and try to resolve these outstanding Brad Miller wind-down issues, and instead would turn her attention, her sympathy, and efforts to helping her friend get through these awful health issues, to include driving him to the doctor in waiting. The Brad Miller wind-down issues and the defendant's increasing severity of health issues would come to a focus in the month of April. This calendar should provide highlights of that progression as you prepare to hear testimony in this matter. Let's see if we can get it up. Oh. Thank you. So the campaign issues and the defendant's medical issues come to a focus here in April 2013. April 2nd is the defendant's gallbladder surgery. That evening until Saturday, the defendant would recover from the gallbladder surgery staying at Jamie and Nation's house. The next week, starting on Monday the 8th, the defendant, the evidence will show, will fail to meet with Jamie to discuss these Brad Miller issues. Tuesday the 9th, 1 week after the gallbladder surgery, is the suspicion of pancreatic cancer, the post-op appointment in this spot, and the thought that he suffered from pancreatic cancer. Wednesday, defendant again fails to meet with Jamie about the Brad Miller issues. Thursday, no different, fails to meet with Jamie. And in essence, up and disappears without explanation that Thursday. This causes great concern and worry for Jamie and Nation. They don't know where the defendant is now. This causes Jamie further professional stress because she, on top of the outstanding Brad Miller issues, she now has her eye towards the first quarter filing is due on Monday, April 15th. The first quarter filing that Sky Blue must transmit to the FEC documenting the financial status of the Brad Miller account. And while normally that financial issue is handled by the defendant for Sky Blue, now it's Jamie and Jamie alone. And she was dependent on a variety of financial information and assistance from the defendant so she could prepare that first quarter report to the FEC. The deadline is coming up on Monday. Finally, that Thursday, the defendant's whereabouts unknown requires, as you'll hear, requires Jamie and Nation to also push back an upcoming vacation plans. Without hearing from the defendant, Friday comes, and sometime that morning, the defendant will contact Jamie and Nation. He'll explain that the day before he was at his job at LabCorp, he'd started working at LabCorp in the last month or two, and that he was terminated. And he was terminated for missing work and all of his health issues. And he lost it. He was overwhelmed. He drove to the beach. He was at the beach now, Friday morning, reaching out to Jamie and Nation. He told them that he would come back at the end of the weekend, would sit with Jamie and help her prepare the FEC report that was going to be due the next day. The defendant indeed comes back Sunday night and goes to Jamie and Nation's house and helps and assists Jamie with that FEC report and spends the night at Jamie and Nation's house that Sunday. Monday the 15th, 1 week before Jamie's murder, Jamie had a meeting with attorney John Wallace. John Wallace was the treasurer of record for Congressman Miller's campaign committee. Sky Blue managed the accounts and the finances and would prepare the FEC report, but it required the treasurer's approval of that report, and once the approval was obtained, Sky Blue would electronically transmit the report to the FEC. So this quarterly meeting with John Wallace, the evidence would show that both Jamie and the defendant go to Mr. Wallace's law office that morning on the 15th. At the meeting, Mr. Wallace is shown the draft report, the draft first quarter FEC report. You're expected to see this. It's a 10-page, rather straightforward document. And the document lists the bank account of the campaign as having close to $63,000 in it. In truth, there is no money. The account is depleted. In fact, it's a few thousand in the negative. Only Mr. Wallace nor Jamie is not aware of that. Also, at this rather brief meeting with Mr. Wallace is informed that the loans Mr. Miller had made to his campaign have been paid back. Mr. Wallace looks at the proposed FEC draft report and sees that these loans still reflect as an outstanding debt the campaign owes to Mr. Miller. Well, they've been paid back, but they're still reflected here as an outstanding debt. This apparent conflict, he doesn't get clarification. He asks for this to be looked into to get back with them on this issue. And otherwise, that ends the morning meeting with Mr. Wallace. After that, on Monday, the 15th, Nation will hook back up with Jamie and the defendant because Jamie and Nation were taking the defendant to Duke Hospital for his first oncology appointment. Jamie and Nation drive him to Duke Hospital. Jamie and Nation will wait patiently for hours while he's at his appointment. The defendant will return and will inform Jamie and Nation the doctors have indeed confirmed that he has pancreatic cancer, and the doctors want him back early the next week on Tuesday for some type of procedure. After this long, certainly difficult, emotional Monday morning, Jamie and Nation are now able to start their delayed vacation. They were going to the beach. They were going to Emerald Isle for the week to celebrate their upcoming 4th wedding anniversary and Nation's upcoming 27th birthday. As Jamie and Nation are prepared to head out of town that Monday afternoon, Jamie has an interesting phone conversation with the bill collector. This is the same bill collector Jamie spoke with at the beginning of April when he called and informed her that he was calling on behalf of the bill collection agency's client, Time Warner Cable. There was a $591 unpaid overlooked bill the Congressman Miller's campaign owed, and he was calling on behalf of that debt. Jamie took the information and would write and send a check, something she's authorized to do, normally didn't do, but would send the check to the bill collector, thought nothing more of that $591 bill. Well, now as Jamie and Nation are prepared to head to Emerald Isle, the bill collector is on the phone telling Jamie that they got the check, but the check bounced. Jamie's perplexed. There should be $63,000 in the account. She assures the bill collector there's plenty of money in the account, but that she would look into the matter and get back with the bill collector. The evidence will show that this Brad Miller issue and the other unresolved Brad Miller issues would be work is tabled, and Jamie and Nation indeed go to the beach to enjoy their upcoming anniversary and birthday. And as is customary for this young and social couple, they invite numerous friends down to come and stay and help them celebrate, to include the defendant, who gets down there Friday and stays with everyone else until Sunday. Sunday, everyone packs up and comes back to Raleigh. Back in Raleigh, the defendant will agree Sunday night that he will return the next day and meet with Jamie and bring these requested materials and try to resolve all these Brad Miller issues. Monday, the 22nd, 4:30 that afternoon, the defendant will drive over to Jamie and Nation's. Jamie and the defendant are downstairs in the front office area of the house when Nation comes home a little early from work, not too long after the defendant had arrived. Nation will greet the defendant, will ask him if he's staying the night again with them, because like last time, Jamie and Nation are expecting to take him to Duke Hospital early the next morning for this oncology procedure. Then Nation will go upstairs, leaving Jamie alone with the defendant. You will soon meet Jamie Hahn. He will describe to you what he hears when he's upstairs and what he sees when he comes downstairs. As difficult as it will be, he will revisit that day with us, the day his heart broke, and it began with Jamie screaming. Nation will come down the stairs, and at the bottom of the stairs, he'll turn back, looking down a hallway to the back of the house into the kitchen. He'll see Jamie lying on the kitchen floor, bloody. He'll see the defendant standing over her, holding a large knife. As Nation starts to the kitchen, the defendant will turn his attention and violence towards Nation, attacking him with that now raised and bloodied knife. Nation will defend himself from the defendant's knife assault while yelling to Jamie to get up and run out of the house. And somehow she's able to do just that. Nation will create enough separation from the defendant's attack, and with sliced hands and lacerated tendons in his ring and lacerated tendon in his middle finger, he'll flee the house successfully as well. This will mark the last time either Jamie or Nation ever see the inside of their once warm and welcoming home. You will learn of kind neighbors calling 911, trying to comfort a quickly fading Jamie. You'll hear of a traumatized and bloodied Nation as he desperately promises his wife that they'll enjoy a long future together. Whether either person knew it at the time, we know those promises go unfulfilled. Jamie will lose consciousness in the ambulance ride to WakeMed, never again to acknowledge her loving husband, to say goodbye to her parents or the large group of friends holding vigil at the hospital until she dies early Wednesday morning after unsuccessful life-saving surgeries. Dr. Lawrence Scott, performs the autopsy. Dr. Scott, sadly, has a lot of information to share with this jury. The reason: Jamie suffered numerous cuts and penetrating knife wounds. Dr. Scott will show you photographs of Jamie's traumatized body and will identify and discuss all of these separate knife wounds. From that hospital, Jamie left this world at that too young of an age. This jury will learn that the defendant also receives medical treatment for self-inflicted injuries to both the wrists and his abdomen he administered right before the Raleigh police responded to Jamie and Nation's house that awful afternoon. This will mark, in truth, the first time that entire year the defendant ever sees any doctor. As you will learn, the defendant makes recorded admissions to investigators, confessing to lying about having MS, to lying about having gallbladder surgery, to lying about having pancreatic cancer. He will admit to embezzling thousands of dollars from Congressman Miller's account. And you will hear the defendant admit to stabbing Jamie with the knife he'd recently purchased and brought concealed in his backpack to her house that afternoon. And with that, this case will not prove to be a whodunit. The identity of Jamie's killer will not be in dispute. And at the close of all the evidence, the state will return to argue that those facts, those undisputed facts, and the controlling law dictates a conviction for first-degree murder as to Jamie Hahn and the attempted murder and felony assault as to Nation Hahn. Thank you. Yes, sir.
Does the defense wish to make an opening statement at this time?
Yes, Your Honor.
Ms. Elliott.
Thank you, Your Honor.
Jonathan Broyhill held the knife that killed Jamie Hahn. That fact is not in dispute. Her husband, Nation, was injured when he tried to save her. And to make this a nightmare that Nation Hahn can't wake up from, John was his best friend. Any way you look at it, this is a tragedy. You're obviously going to hear a lot in this case about Jamie and Nation Hahn. The state is going to present evidence to try to make you understand who Jamie Hahn was and the pain that Nation Hahn has gone through in losing his wife. But as much of a tragedy as it is that Jamie Hahn isn't still here with us, and while Nation and Jamie Hahn are obviously essential to the story of this case, this trial is about Jonathan Broyhill. So let's take a few minutes and talk about what evidence you're going to hear about John. As you've heard, John grew up in Lenoir, North Carolina, a small town in the mountains about 2.5 hours from here. John and his sister were raised by his mom and dad. Their Christian faith was a big part of their lives, and you're going to hear that from his first day of kindergarten, John was enrolled at Harris Chapel Christian Academy, a very small private Christian school in Hudson, North Carolina, just outside of Lenoir. John attended that school until he graduated from high school in 2000, graduating in a class of 3. In addition to his school, John grew up going to church at Whitnall Pentecostal Holiness Church. Nation Hahn also grew up going to this church, but it wasn't until later that he and John became friends. John was well liked in town, both at school and in the community, and he began working part-time at Lowe's Foods, bagging groceries while he was in high school. You're going to hear that in the spring of 2000, John's parents separated. This was an event that had a big impact on then 18-year-old John. And just before he graduated from high school, John's mother moved out of the house he had grown up in. This event led to John growing apart from his mother, eventually becoming almost totally estranged from her by the time these events occurred in April 2013. In the summer of 2000, just after he graduated, John went on a summer camp trip with his church and got to know Nation Hahn. Although Nation was just entering high school that year as a freshman, the two became close friends. Even though John began working full-time at Lowe's Foods, he and Nation Hahn would still see each other 2 or 3 times a week. You're going to hear that this upbringing in a small town, in a conservative Christian family, was hard on John, as he began to realize that he was different. One of the reasons that he and Nation became friends was that they knew their beliefs were similar to each other's, but different from other people's in their community, including their families. By this point in John's life, his relationship with his mother was already strained, and he knew he was hiding part of who he was from the rest of his family. Nation Hahn left for college at UNC in the fall of 2004. While he and John didn't remain as close once Nation moved to the Triangle, John went to Chapel Hill to visit a few times, and they would see each other whenever Nation came home to Lenoir on breaks from school. Meanwhile, John stayed in Lenoir and eventually traded bagging groceries at Lowe's Foods for pushing paper at Universal Mental Health in nearby Morganton. He was still living at home with his father and stepmother and still kept in touch with Nation Hahn, who was finding out the world was much bigger than Lenoir. In the spring of 2008, just before Nation graduated from UNC, Nation started dating Jamison Kirk. That spring, Nation introduced Jamie and John, as you've heard. Jamie Kirk and Nation Hahn moved to Charleston in April 2008 to work on a congressional campaign. John and Nation's friendship got closer again, and later in 2008, John went down to Charleston to visit them. It was on that trip that John came out to Nation and Jamie and told them that he was gay. This was not a big deal to either Nation or Jamie, who loved him regardless. It was a big deal, however, for John to come out to them, since that was a part of his life that he felt he couldn't share with many others, particularly his family back in Lenoir. You're going to hear that Jamie and Nation Hahn got married in South Carolina on April 18th, 2009, and John was Nation's best man. Clearly, their friendship had gotten very close again. Within the next month or so, Jamie Hahn started Sky Blue Strategies, a political consulting firm. And within a few months of that, in the fall of 2009, John finally left Lenoir, moved to Raleigh, and moved in with the Hahns. When he moved to Raleigh, he was still working for Universal Mental Health and had transferred from Universal's Morganton office to their Raleigh office. But in under a year, John left his job at Universal and began working full-time with Jamie Hahn at Sky Blue Strategies. You're going to hear that, as some of you may know, the political business is feast or famine. So there were times when John would essentially be laid off from Sky Blue Strategies and would go on unemployment. This happened after the midterm elections in November 2010 until April 2011, when he became an employee of Sky Blue Strategies once again. During all of this time, John and the Hahns were incredibly good friends. Not long after John moved to Raleigh, they started going to church together at Pullen Memorial Baptist Church. They shared the same group of friends for the most part. Even after John moved out of the Hahn's house in February 2010, he still spent a lot of time hanging out at their house. It will not be in dispute that the Hahns saw much good in John, and he in them. Friends say that the three of them were always together. Neighbors say that up until the events on April 22nd of 2013, they assumed John lived at Jamie and Nation's house on Tealwood Place because his car was always there. And so while you will hear about many good times that Nation and Jamie and John had, you're also going to hear things about John that reflect deep problems. For example, once John started working for Jamie Hahn again in April of 2011, Sky Blue's main client was Congressman Brad Miller. Sky Blue was responsible for running Congressman Miller's campaign. As part of his responsibilities for Sky Blue, John had sole access to Congressman Miller's federal bank account. In June 2011, John began writing checks to himself. He continued writing checks to himself on a somewhat regular basis over the next nearly 2 years. All these checks ended up totaling close to $50,000 that John embezzled from Congressman Miller's account. You'll also hear that beginning in 2012, John began lying to those closest to him, mainly Jamie and Nation Hahn, about his health, that he had been diagnosed with multiple sclerosis, that he had gallbladder surgery, that he had pancreatic cancer. Those were all lies. John told other lies as well, that he got a job at a place called LabCorp, that he was then fired from LabCorp, that he was overwhelmed by all of his medical issues and his firing from his job, and took off to the beach for the weekend to think about his life. Those were all lies. We anticipate that over the next few weeks, the state is going to say that this is about the money, and that John lied to distract Jamie and Nation Hahn from his acts, and that when he knew he couldn't get away with the theft anymore, he attacked those he loved. But John had no preconceived motive to kill those he loved, because the undisputed evidence will show that John was determined to take his own life. When you look at what the facts really show, the evidence is going to paint the picture of a tormented soul who had become so depressed and so despondent that he was ready to end his existence. The evidence will prove that the lies John told point not to a cover-up, but are the acts of a man who was overwhelmed by life. When you look at all of the facts of this case, you'll see that all of his actions, his stealing the money, his lies, it's all so irrational, it's all so bizarre. It doesn't point to a person bent on covering up his crimes. The evidence is going to show that all of the facts of this case point to a person who wants to leave this world. And on that point, there can be no question. Because in addition to stabbing the two people that he was closest to in the whole world, on April 22nd, 2013, John also used that same knife on himself. He slit both of his wrists, plunged the knife into his own stomach, and laid on the floor of the Hahn's kitchen, waiting to die. The question of why John turned on his friends might not be answered in this trial. He had no motive to kill those he loved. Something snapped. As I said in the beginning, this case is a tragedy. It is a tragedy committed by a sick person who was ready to end his own life. There was never any premeditation. John went over to the Hahn's house that day. John never went over to the Hahn's house that day, intending to kill Jamie Hahn. The facts will show that John never went over to the Hahn's house that day, intending to injure Nation Hahn. The facts will show that the only person John planned on hurting that day was himself. There was one motive that drove John to do what he did that night: suicide. At the end of this trial, we will not come before you and argue that John shouldn't be held responsible for his actions or accountable for what happened. The acts that John committed led to an unspeakable tragedy. But those acts were entirely irrational. What John did was not premeditated. It was not deliberate. What happened on that night was not first-degree murder. Thank you.
Ms. Elliott. All right, ladies and gentlemen, we're going to go ahead and take our mid-morning recess till 11:15. When you return, we'll have the notebooks out for you, and we'll be ready to call the first witness in this case. So while you're on recess, please recall the instructions. Don't talk among yourselves or with anyone else about this case. Don't form or express opinions about the outcome. No media or independent investigation into these matters. Please have no conversation or communication with parties, witnesses, or lawyers. As it may have been explained to you by the bailiff, we'll ask you to exit through this door here, and you're welcome to use the jury deliberation room at this time. You're welcome to go out through the corridor and exit. The bailiff will explain all of that to you. When you return at 11:15, we'll ask that you all gather in the deliberation room. We'll bring you out as a group. if you'll follow the bailiff out. Everyone else, please remain seated. All right. Anything that we need to take up before we recess for a few minutes?
Not for the state, Your Honor.
All right, and let me just ask the people in the gallery or remind the folks to please give the jurors space. Namely, if you are in the corridor and a juror is walking by, they all have red badges. Just stay very clear of them so there can be no mistaking that no one is violating the rules that I've recited to the jurors. Those rules apply to everyone involved in this case. So we do ask that you just simply give them space. If you're waiting for an elevator and one comes, and it may be best for you just to wait for another one, things of that sort, so that they feel no discomfort being around people who may be involved in this case. So thank you very much for your cooperation on that rule. We'll be in recess until 11:15.